Now, just to have an idea of what you're going to be urging, Mr. Salve, you are opposing the reference, or what are you saying?
Yes, my lord. My lord, in fact, I'm opening by telling you, my submission is that the issues when they were framed, we had mentioned this, but the issues which have now and the events which have now transpired are such that there is no need for this reference. And in fact, the reference would be contrary to the writ petitions themselves. That's what I propose to point out. I open by saying, my lord, we heard yesterday impassioned plea by Mr. Sibal saying how the defection law has failed to curtail defection. And my lord, yes, of course, ultimately no law can completely fill in the gap left by morality. So that's where we are. If Mr. Sibal said the speakers have failed to rise to the occasion, my lord, I don't think there can be any cavil about that, the kind of cases which have come. But also, my lord, equally, this we should always remember this was an anti-defection law, not an anti-dissent law. The challenge and the criticism include right from the late Mr. Palkhiwala, who was one of the great votary of political morality. Always the criticism of such law also used to be that this becomes an anti-dissent law. And that is what this is being converted to today. If I give your lordships 5 or 6 dates, your lordship will see that none of these petitions survive. Unless your lordships, and that is not really even for a bench of 5, unless your lordships come to the startling conclusion that under 142, applications pending before a speaker can be transferred to this court and tried. And that's one of the prayers in one of the writ petitions. Or an even more startling conclusion saying the moment there is a disqualification petition filed, the candidate stands disqualified until he is requalified by rejection of the dissent petition, by the defection petition. But those are not matters, my lord, which 5 of your lordships will refer to 7. What your lordship is today concerned is with the Nabi Mirabia problem. I will not take any time reading that judgment beyond saying that there was a serious problem in that case. There is a strong argument that you should not hold speakers to be in suspended animation merely because a dissent removal is pending. But Justice Misra particularly, Malad, brings out the counterpoint. Suffice it to
Justice Mishra brings out their voice.
counterpoint. The counterpoint.
The counterpoint.
Yes. And I'm only saying this for the reason these are delicate constitutional issues which should be resolved in a fit case where the question arises. Does the question arise in this case? And the answer is a resounding no. And let me tell my lord why. It is, my lord, in our counter affidavit, if your lordship turns to page 494 of volume 1, convenience compilation. What exactly happened and what has happened and where are we today? The only petition in which Nabi Mirabia today is a live issue is a petition settled by Mr. Kamath, who perhaps realizing the folly of his ways has argued that Nabi Mirabia should be reversed. It's a petition by a group of people against whom the Shinde faction has filed defection petitions. They have come to your lordship saying because of Nabi Mirabia, because we have applied for removal of the current speaker, do not allow him to continue. Now, if they say the judgment is wrong, all they need to do is withdraw their petition. Look at that, Malad, for a minute. Because I think that's what is important to know. In such a delicate constitutional issue, your lordships are embarking on a journey which has no destination. Page 494, my lord, we give the dates.
Of 494 of?
Of compilation 1, volume 1. My lord, PDF page 494. 497, sorry. I hope I've got my PDF pages right.
It's a common reply of the
It says convenience compilation volume 1.
It starts on the top as common.
Factual matrix. Correct. That's that. Factual matrix मिल गया?
Have your lordships been able to find that?
Where it says factual matrix.
Well, at the first sentence in that is in a sub paragraph 7 saying on 21st June 22.
Chief, it is. Yes, Mr. Salve. Whose counter is this?
This is Malad from our side.
Right.
21st June 22. It starts by saying it came to the knowledge of the answering respondent. Answering respondent here is the current chief minister, Mr. Shinde, and other members of the Shiv Sena legislative party. They have used SSLP, the acronym for that. That a minority faction, only 24 out of 55 MLAs attended an authorized meeting, passed a resolution to remove the answering respondent as leader and appointing Ajay Chaudhary as the group leader. Then next para it says on 21st June, 34 MLAs of the SSLP passed a resolution reaffirming that the answering respondent was appointed as a group leader, etc. The resolution was clearly stated that appointment of Ajay Chaudhary is illegal. Now, this is all the wrestling going on with the appointment of the leader of the party. This is all happening on 21st June. Para 10 says on 21st June, 34 members of the Maharashtra Legislative Assembly issued notice under Rule 11 of 179 to Mr. Narhari Zerwal for the motion for removal of the Deputy Speaker. Now, this motion was never carried to fruition. In fact, he continues even today as Deputy Speaker. 24 June 22 is the next event, small 11. Answering respondent came to know that Secretary Maharashtra Legislative Secretariat communicated that a request made by the petitioner to recognize Ajay Chaudhary has been recognized by the Deputy Speaker. So, the other faction's person is recognized as the Deputy Speaker. Then, 22nd June, Sunil Prabhu, claiming to be group leader, issued notice. There were cross notices to each other. Your lordship may drop down to page 501 PDF, para 14. In a meeting held on 22nd June of the Shiv Sena, which was held by 14 out of 55 MLAs, held at Varsha Bungalow, it was resolved that those members who did not attend the meeting should be disqualified. Now, my lord, the submissions before your lordships have proceeded on the footing that there is a disqualification petition by which all the MLAs will go. What your lordship had not told was only 16 petitions were actually filed. So that's the number in count. Then, my lord, small 15. Accordingly, on 23rd June, Mr. Sunil Prabhu filed a petition under Rule 6 of the defection rules against the answering respondents and a few MLAs for not attending the meeting on 22nd. Now, my lord, please see the next paragraph 16 at 502. And this is why petitions were filed in this court. Forget the Navim Rabia point. Answering respondent along with few other MLAs received summons on 25th June by Principal Secretary for disqualification, etc., etc., whereby the respondent and others were directed to file a reply to disqualification petition on or before 27 June. Now, my lord, this is even against the rules. You have to give a minimum time. The speaker was rushing ahead. Then, my lord, on 26th July, should be 26th June actually, the answering respondent and other MLAs filed. Therefore, my lord, this was the original petition filed. And in this, my lord, para 18 says on 27 June, this court said we extend time till 11th July. Now, this court did not say that the speaker shall be in suspended animation. By extending the time to file a reply and by compelling these people to file a reply, the court has in fact allowed the speaker to function. Now, we were therefore given time up to by the court till 11th of July. In the meanwhile, my lord, on 28th of June, the Maharashtra asked Mr. Uddhav Thackeray, the chief minister in office, to prove his floor majority. And on 30th June, my lord, a session is convened on which Mr. Thackeray is to prove his majority. On 29th June, Mr. Sunil Prabhu moves your lordships asking for a stay of the session. The court declines it. When the court declined to stay the 30th June meeting, Mr. Thackeray resigns.
So there were two. The actual scenario was this. By our order of 27th of June, we had
Yes.
extended time until the 12th of July. to
11th of July.
responses,
Sorry, 11th
the
July.
disqualification notice.
12th July.
Yes.
But in the meantime, as a result of the direction of the governor, the floor test was to be held on
Yes,
30th. In other words, the floor test would take place without the speaker applying his mind to the disqualification.
Correct. Correct. They came to your lordships and said, stay this meeting.
Right.
Your lordship said no. Now, the legality of that meeting is no longer an issue because Mr. Thackeray resigns.
Just one.
So there was no meeting on 30th June. So, my lord, the question of the defected or the challenged 16 MLAs voting on 13th June did not arise because there was nothing on 30th June. Mr. Thackeray walked away. So even that question of law doesn't arise. And on that date, I want to give your lordship admitted figures. There are 288 MLAs. The BJP and the independents who support it are 115. With the
115.
Congress and the
115.
115.
All right.
So the balance 173 is what used to be the Maharashtra Vikas Aghadi. Give or take one or two here or there. Gap of approximately 58. And there are 16 disqualifications. So it was not because of the disqualification pending petitions which tilted the result either way. And Mr. Thackeray saw that and walked away.
So the disqualification was sought against 16 totally.
Yeah, yes, those are the petitions pending. That's the figure I've not been given.
So these, according to you, wouldn't have made a difference even if their votes were to be excluded.
Even if there was a meeting in which they had voted.
Just factually, 27th June, 22 more were sought to be disqualified. Just
27th.
7th of June, 22 more were sought to be disqualified by the petitioners. Just so that the facts are before you.
Yeah, I accept my friends.
Any disqualification
Notice was never given of that.
Yes, yes.
1 minute. Any disqualification notice you had given?
Yes.
No.
No notice was given. Please take a.
Petition was filed. Petition was filed. That's all right. The petition was filed for 22.
It was only the initial notice.
My lord, may I? So let's
Understanding the facts.
the facts are clear. Our writ petition related to 16. For the balance, 22 petitions may have been lodged, but the speaker took no action. On 27th June. This is when Mr. Thackeray is still chief minister. Now, in a scenario like this, if the chief minister resigns and there is no trust vote, what would have happened on the trust vote? Would these people have changed their mind in view of the pendency of the petition and supported the chief minister? Would they not have supported the chief minister? All those questions don't arise because there was no trust vote.
For their petitions to be really live petitions, that they should have faced the trust vote.
Yes. Then some questions may have arisen
Voted
about
out of
what
office
happened.
on the trust vote.
Yes.
And then you would know who are the actual people who voted
Exactly.
in favor of the trust vote and who was sought to be disqualified.
That's right. None of that ever happened. Now, my lord, 30th June, let me, and my lord, one thing is clear, by now Nabim Rabi has all become academic. Those 16 disqualifications petitions are still pending. On 30th June, the current incumbent, Mr. Shinde, gives a report to the speaker showing majority. The governor directs a floor test on 4th of July.
What happened on 30th June?
My lord, the current incumbent goes and moves the governor. He's made chief minister. And on 30th June, my lord, the governor says, prove your majority within 4 days. Now, my lord, in the meanwhile, there was no speaker. Your lordship knows all this rumpus is about the deputy speaker acting. So on 2nd of July, the election of the speaker is filled on 3rd of July.
Notice election of
End of July, the notice for the election.
Now the speaker is fixed for 3rd of July. Your lordship gets these facts in para 26.
Second notice was third election.
Now there are two whips. My lord, one is Mr. Prabhu who's acting. on the Thackeray faction. He says he issues a whip saying vote for Mr. Rajan Sarvi. And he issues a whip to vote against the confidence motion on 4th of July. In the meanwhile, my lord, Ajay Chaudhary, and this is the important part, 28. He is the Thackeray faction appointed leader, issues a letter to the Deputy Speaker requesting him not to consider the vote cast by the members against whom disqualification is pending. Then, my lord, election of the Speaker is held. Now, my lord, all this is academic because the Speaker's election is not under challenge before your lordships.
That's also which
Actually, it all boils down to this, that they didn't face the trust vote, according to you.
Correct, my lord, as far as the first round is concerned.
And the total number of petitions in respect of which disqualification was sought was 16. There was
Correct.
disqualification was square 16.
Now, your
22
lord
came in later, no notice was issued by the speaker, and then everything was overtaken by the events.
events, and today you do not have any assertion before your lordship saying, if you take even the 22 plus 16, 38, the election of Eknath Shinde is vitiated. Because by the time he was elected, my lord, after Thackeray resigned, political events then changed. My lord, people who were on one side shifted to the other side.
that's
Mr. Salve,
Yes, my lord.
also show us the prayers in the writ petition.
I was immediately
Which
going
has
there.
been filed,
Yes.
has been filed against the decision of the governor on 28th of June 22 to hold the floor test.
Page, my lord, that is writ petition 493. I was immediately going to take your lordship there. This is in the convenience compilation. It's the first writ petition.
Ultimately, what happens is really the two judicial orders really seal the fate of the
Correct, my lord.
first order of the 27th,
Yes, my lord.
which says that, we give you time, extend time until the 12th
Yes.
to submit your reply on the ground that the speaker had given only 2 days time. Therefore, the first order says time until the 12th. Then when they came back to the court, challenging the convening of the trust vote on the 30th, our court said no stay. So really speaking, everything, it was these two orders ultimately
And
which
but
affected
my lord,
the first order had the consequence of
Yeah.
not allowing the speaker to go ahead with the disqualification petitions
Of 16 people.
before the 12th.
Of only 16 people.
Of 16 people. And the second order had the consequence of ensuring that the trust vote takes place on the 30th.
Correct. Except the
And they
trust
knew,
vote.
I mean, the Uddhav Thackeray faction knew that without a decision on the disqualification petition, the trust vote was sealed then.
My lord, there also I'm saying the gap was, no, my lord, the gap was 16. No, that's not correct. That is not correct because, my lord, the disqualification petitions which were deferred by your lordship as 16, they had 58 majority.
I beg your pardon, come again?
The 16 petitions were adjourned.
Right.
The gap was 58 between the BJP and the Agadi.
Yes.
So if you take the 16 out,
That's not the point. Eknath Shinde became the chief minister.
first Mr. Thackeray resigns, then Eknath Shinde becomes chief minister. It's not in the reverse sequence.
So what?
Now, there is no legal, if Mr. Thackeray had contested the election, the effect of which had been in any manner impacted by the non-decision of the defection petitions, some question of law may have arisen.
Yes.
So, my lord, saying put him back means your lordship will then have to declare his resignation illegal. That's the only way he can come back. Now, my lord, let us see what are the petitions before your lordships. Please turn to page 99 of the first petition.
PDF page 10. He said we are not challenged.
I think Mr. Sibal doesn't realize his mic is on. I can hear everything he's talking to his juniors.
Oh. I'm not saying it. I'm not revealing a state secret.
Not yet.
All is the light away.
My lord, I was waiting.
Mr. Salve is just cautioning you. 99, is it?
Yes.
99 of the same affidavit, of the same compilation?
Yes, my lord.
Yeah, first.
PDF page 102, perhaps.
493, serial number 1 of the bookmarking of the conveyance.
Two?
Yes, it's bookmark 1.
102.
Is right. It's bookmark 1.
Yes, the bookmark one. You got it, yes.
Yes. And at page 102, because I have 3 page numbers, but I think PDF is 102.
This is writ petition filed against 36. Okay, I get it.
Yes, 30th June. My lord wanted to know the
Yes,
challenge
yes.
to the governor. Pass an appropriate order or direction quashing the decision of the governor to invite respondent 4 to take oath as chief minister. Pass an order declaring illegal proceedings of the Maharashtra Assembly heard on 3rd July. And pass an appropriate writ held on so and so.
Also, election of speaker. Just read that.
Yeah,
Yes, and also challenge the election of the speaker.
Yeah.
Now, my lord, most important is D. And I submit D is none of this has Nabi. I'm only answering whether your lordship needs to refer Nabi Arabim to 7. Look at D. Call for records of all pending disqualification petitions against so-and-so pending before so-and-so.
Yes. This is what I was asked. So then,
3 of your lordships will hear these someday and decide whether this extraordinary relief can be given. And whether your lordships can say we will become the election tribunal. The 3 judges or 2 judges of Supreme Court for the first time will try a disqualification petition. But I think it's... So this is, my lord, one petition. This is, I believe, writ petition 393, 493. The second, my lord, is the challenge to the trust vote, which is...
Yes. This is the trust vote challenge.
which is writ petition 470. I think that is number 9 on the bookmark. Page 351. Petitioner, whip of Shiv Sena, member of the Legislative Assembly, is constrained to move the court on 29 June, challenging the completely mala fide unconstitutional illegal actions of the governor. The governor, by communication of June, which was received as in complete defiance of the fact that the court is seized of the issue of disqualification in a desperate attempt to allow the members who have incurred disqualification a safe passage to hold a floor test on 30th June. His point was that your lordship is considering the validity of the disqualification proceeding.
Question is,
Yes, Mr. Salve.
Yes. Now, my lord, as far as Nabia Rabim is concerned, before I show my lord two more writ petitions, then I'm almost done. It could have applied in two situations. Had there been a trust vote on 30th, and there been an injunction in place, and that I'm assuming that your lordships may have been influenced by Nabia Rabim judgment to give time to 11th of July. Let's assume. The
So
page,
when would have Rabi applied if there was a trust vote actually on the 30th?
and if a court had restrained the speaker from acting, the court only said give time to 11th of July. We are, my lord, today on the 15th of February 2023, the petitions are still pending. And there was a reason why the speaker has done nothing. My friends remind me, because there was a set of cross disqualifications filed against the other group who voted against Eknath Shinde. And they came and complained saying that the new speaker will rush ahead and disqualify. And there was an understanding, keep everything in freeze. Because now there is a speaker, there is no deputy speaker. So obviously these will stand transferred to the speaker and let the speaker's appointment is set aside. So, and they said we have challenged the speaker. So everything is on hold. So Malad, this Nabia Rabim had no role to play in all the events that have transpired. No court had issued a mandamus based on Nabia Rabim, which is an appeal before your lordships. And your lordships have to consider if this judgment was wrong and this mandamus had not issued, then how do we restitute? None of that ever happened. I can understand, my lord, if we had gone to the Bombay High Court following this judgment had stayed the speaker, then the events transpire, appeal comes, your lordship says, no, this Bombay High Court judgment is wrong because we are going to reverse Nabia Rabim. Now how do we restitute? None of that happened. My lord, one thing I will say, when the disqualification law was inserted, there was a clause added originally, which said if you are expelled from the party, you lose your seat. There was a criticism that time, my lord, it was the late Mr. Rajiv Gandhi's government, which had, we know, my lord, had an overwhelming majority. One of the largest ever in parliament. There was a criticism saying, is this a measure that now we have everybody inside the barn, we want to lock the barn door? He dropped that clause. The clause was dropped from the provision when it was finally made, brought into the constitution. Mr. Ashok Sen was law minister that time. So, my lord, this should also, the anti-defection law also is not a weapon for a leader who has lost faith of his numbers to hang in, because there are layers of political morality in each of these. And my lord, it is best your lordship stay away from all that. Because these are very complex questions. Now, my lord, the second writ petition is bookmark number 9. My lord, Justice Narasimha asked me where is the challenge to the 30th June governor's action. This is that writ petition.
Prayer.
Yes. And in this, my lord, the prayer, I'll give your lordship in a minute, is on page 400, sorry, 408.
377, 374, 375 or 377 of the PDF.
Yes, my lord, 377 of PDF.
Challenging the communication of the governor.
That's right. Now, this has clearly become academic because, my lord, on that communication, no meeting was held.
Yeah, I think, look, there should be no trouble. Yeah.
Then we have item 10. Bookmark 10.
It is and it isn't academic, but for the communication of the governor, they wouldn't have resigned.
Maybe, but my lord, if your lordship set aside that communication, what happens?
Ultimately, Uddhav Thackeray, he resigned because of the communication of the governor to hold the trust vote.
Correct. My lord, if he had gone,
he knew that, well, if I have to face the assembly the next day,
yes,
without the disqualification petition being heard, he doesn't have the numbers.
No, my lord, that again is wrong. 16 disqualifications alone were stayed.
Yeah,
11
that's what
July.
you made. 16 plus 22 also you said if you exclude.
38, there's still 58. Secondly, my lord, as a court, political events, your lordship is right. But as a court, if he did not face the trust
I mean,
vote,
what you're saying is that there was never any trust vote, so why challenge the communication?
I mean, it's academic because there was the communication goes, what happens? The meeting doesn't go.
It's academic in the legal sense, you're right.
In the legal sense. Correct.
It's all part of one
And
intrinsic.
that's why, my lord, that's why, in my respectful submission, it is hazardous for your lordship to be drawn into.
Right. Anything else, Mr. Salve? Should
Yes.
we
Just want to finish the record.
20 minutes by about 20 minutes?
Yes. My lord, the two more writ petitions remain. I just want to.
Yes. Which are they?
My lord, that is, I'll just give your lordships the bookmarks. Item 10, that is challenge to Mr. Gogavle.
10 is 479.
But what is important, my lord, and I finish with this, is item 11 by the petitioners.
Item 11.
Yes.
That is Sunil Prabhu.
Relying on Nabiapro. And on which the speaker has held his hand because there was understanding that nothing will be done. And now they are saying this is wrongly decided. Page 412, my lord, your lordship has page 412.
Page?
412.
Yes, and the prayer is at 461.
Yes. No, before that, please just see 414.
414.
Yes. There is a paragraph saying secondly.
It's true because we are saying that no.
Now the petitioners are saying this judgment is wrong. There has to be some rule of holding people to what they have come to court.
It will never apply to.
414 you said.
Second.
ये कहाँ है?
Page
411 otherwise.
411.
411 on the right side, Manoj. I believe the PDF page is 411.
That's right.
This is their petition, right?
Yes. Which relies on Nebi Arabi. Now you can't say this is the law, so on this I'll get a stay, but I'll get up and argue that this law is wrong.
In this petition, in the counter affidavit, did you say that Imam Rabia is wrong?
No, Manoj. we were careful. except the roles are reversed. Manoj, I will end by...
The bottom line is,
Yeah.
Navam Rebia becomes right or wrong based on, which side you are in which political situation.
Manoj, I will only end by...
Somebody or the other is supporting it. The same people are supporting Navam
Correct,
Rebia.
correct,
The same people
But
oppose
I-
it, depending upon which way.
I've said what I had to say about this, Manoj. This is not a fit case to decide these issues. I will only close, Manoj, with a story which Mr. Parasaran once told us, told a constitution bench of your lordship's court, saying in Satyug, a man was a tenant of a farm. He found a pot of gold. He went to the owner and said, this belongs to you because I only have the farm for cultivating grain. The owner said, no, God willed you to get it. That is why you discovered it. So they had a dispute. They went to the king, by which time it was Kali Yuga. So contrary to their pleadings, as he explained, the tenant said, this is mine because I found it. And the owner said, no, this is in my land, therefore it is mine. So that is what is going on here.
And ultimately, king said it.
Seizes power, gets the pot of gold.
What the king said is what I want to persuade your lordships to hold. Don't waste my
For
time.
any treasure, we have an act, right, in India. We have an act of 1972, the Treasures Act. When a treasure is found, it belongs to the treasury.
Treasury.
Yeah, it was.
The constitution.
I was only going to close by saying,
Now the
your lordship should do what the king did. Tell both of them, don't waste our time. That, my lord, is my submission.
All right. Thank you, Mr. Salve.
Lordship, please.